In cases of honor killing, the situation would be that a brother that kills his sister in the name of honor would be forgiven, would be pardoned by his own parents. There was a version of the bill which was tabled around 2014 and 2015, which sought to amend the compoundability provisions of the Code of Criminal Procedure. And in Kandil Baloch's case, we saw that her brother was acquitted of her murder on the basis of a compromise. According to reports by the Human Rights Commission of Pakistan, from January to November of 2024, there were a total of 346 honor killings across Pakistan. The majority of the victims were women. These represent the official figures, these represent the reported cases. Many cases of honor killings go unreported, and the official figures do reflect a degree of underreporting. According to the Sustainable Social Development Organization, in 2024, there were a total of 547 honor killings across Pakistan. Recently, there was a case in Balochistan where a couple was killed. They were surrounded by several armed men. And this is not an isolated incident. It is not a one-off incident. Honor crimes, honor killings are pervasive. In January of this year, a man killed his 15-year-old daughter on account of content that she posted on social media, on account of her social media account. And in most cases, in many cases, the individuals that commit these crimes are related to the victims. They are committed by the brothers, fathers, uncles, husbands of the victims. And those that commit these crimes believe that they have a license to kill when a person violates the honor code. And violating the honor code can mean marrying out of your own choice, having a career of your own choice, and in many cases, the exercise of basic, fundamental female autonomy. And a human life is considered secondary to a man's perception of honor. A man's perception of honor is perceived in some cases to lie in the actions of women, in the choices of women, and in the decisions of women. To a large extent, the courts tended to afford leniency to men that claim to kill in the name of honor. The defense of grave and sudden provocation was used, and when a man claimed to kill in the name of honor, the provocation defense was used as a mitigating circumstance. And effectively, the courts would say that men get angry easily, men react quickly, they're reactive, men get emotional, and they get provoked by the actions of women, and therefore the defense of provocation was invoked, and it would be treated as a mitigating circumstance when men claimed that they killed in the name of honor. And there are several cases where the provocation defense was used. In Abdul Haq versus the state, the Supreme Court said that the offender was very sensitive about derogatory statements about women folk and reacted very quickly, and the provocation defense was invoked. In Muhammad Ayub versus the state, the Lahore High Court said that the offender could not tolerate anything with regards to the female and their conduct, and that he was of an age group where tolerance was non-existent, and therefore he tended to react very quickly. And effectively, the courts would be saying that where honor was invoked and it was claimed that the killing was in the name of honor, it was natural for a man to react like that. It was normal, and it is an emotional, natural response, and it would be reducing the severity of the crime. And in some cases, the mere statement of a man that he killed in the name of honor was considered enough to invoke the provocation defense. In cases of honor killing, the situation would be that a brother that kills his sister in the name of honor would be forgiven, would be pardoned by his own parents. And there have been various amendments to the law. In 2004, a definition of offenses in the name of honor was included in the Pakistan Penal Code. In 2016, more significant amendments were made. Offenses in the name or on the pretext of honor were included in the definition of fasad fil arz, which means mischief on earth. A minimum penalty of life imprisonment was prescribed, where it was shown that a murder was committed in the name or on the pretext of honor, and the courts were empowered and given the authority to reject a compromise, even where the heirs of the victim pardoned the offender or entered into a compromise with the offender. And since the amendments, there have been various decisions by the courts courts, including a decision in 2022 by the Peshawar High Court, where it was held that in cases of honor killing and where there has been an honor killing, even if the heirs of the victim pardon the offender, the minimum punishment of life imprisonment would still apply, and therefore the courts have sought to affirm the minimum punishment that has been prescribed in the law. However, even post the amendments to the law, the fundamental problem is that the courts retain significant discretion. And there was a version of the bill which was tabled around 2014 and 2015, which sought to amend the compoundability provisions of the Code of Criminal Procedure, which could not be passed due to opposition by the religious parties, and therefore the 2016 law was passed, which gave significant discretion to the courts. And in Kandil Baloch's case, we saw that her brother was acquitted of her murder on the basis of a compromise. And in Kandil's case, her legal heirs were her parents, who pardoned their son who entered into a compromise, and on that basis, he was acquitted. And in that case, the court held that it was not an honor killing and there was not enough evidence, there was not sufficient evidence to show it was an honor killing, even though there was evidence which showed that Kandil's brother killed her for her photos, for her pictures. And despite this, the court held that it did not fall within the scope of an honor killing, and therefore the amendments would not apply. Even where there have been amendments to the law, the courts have interpreted in a way and have applied it in a way where victims have failed to get justice and where victims have not been given justice despite amendments to the law. And therefore, when it comes to the judiciary and the judiciary's ability to dispense justice, the fact that the judiciary is in our country a predominantly male-dominated judiciary, there is a degree of unconscious bias when it comes to crimes against women, when it comes to gender-based violence, when it comes to honor killings, and when it comes to the justifications that men give as to why they have killed in the name of honor. And when it comes to our judicial system, there must also be, at the investigation stage, female police officers in police stations, because female victims, female family members of victims, and female witnesses will be more forthcoming with female police officers. And therefore, there is a degree of gender sensitization which is essential at the investigation stage and at the judicial stage as well. And the state must also take strong action against tribal jirgas, against parallel informal systems. And in a statement by Amnesty in 2023, they held that the government of Pakistan has failed to take adequate action against tribal jirgas, against these informal systems that are perpetuating patriarchal violence. And therefore, there must be accountability for informal systems that are sanctioning crimes against women. And as of right now, and as of the state of the judiciary, the state of the country, the laws are not being implemented and the courts are not exercising their discretion, and the crimes against women, honor killings, are continuing, and no civilized society allows tribal systems, informal systems, and parallel systems to take the law into their own hands. And therefore, this aspect must be considered when we speak about honor crimes and crimes against women.